Be ready. Start. The judgment of the Supreme Court in the 16th presidential reference has been criticized and praised in equal measure, with the repercussions from this verdict analyzed threadbare. The core issue concerns the fixing of timelines to the functions of high constitutional authorities, while the reasoning in the judgment signals judicial deference to the written constitutional language. It also comes across as an abdication of the ultimate judicial function to interpret the Constitution in accordance with the changing times. Such hesitation does not bode well for a court that is endowed with tremendous constitutional powers of judicial review. It is common knowledge that the Constitution of India is silent when it comes to prescribing timelines for the actions contemplated to be exercised by various authorities such as the President of India, governors of states, and speakers of the houses. Take the case of speakers in parliament and legislative assemblies. Among other duties, they are mandated to perform the role of a quasi judicial tribunal to decide the defection of elected members. This power is provided under the 10th schedule to the Constitution, but there is no timeline specified for completion of defection proceedings. This gives rise to a constitutional anomaly. While the term of the Assembly and Parliament is fixed as 5 years, the non stipulation of a time period for deciding a defection petition means that theoretically the tenure of the elected member could expire without the member ever facing the lawful consequence for committing the wrong of defection. In the recent past, this anomaly has played itself out in a number of states, thereby effectively defeating the very ideals that led to the inclusion of the anti defection law. Similarly, the actions of governors in withholding the legislative businesses have led to a number of disputes. This surely could not have been the intent of the Constitution or its drafters in providing for gubernatorial functions. The question here is not whether governors have the power to return the bills to the government for reconsideration. It is whether governors can sit on duly passed legislative business without any regard for time and effectively nullify a validly enacted law. The answer is in the negative. Only constitutional courts have been granted the power to strike down legislative and executive actions if they are found to be ultra vires. Ironically, the verdict in the presidential reference leans in favor of not imposing any timelines, The judgment argues that the constitutional design did not include or prescribe any timeline in Article 200 and therefore discourages any such stipulation for constitutional functionaries. This has the effect of upholding the actions of governors in practically blocking the laws passed by elected state assemblies. This amounts to more than just ceding of their judicial review powers to the governors. It fails to apprehend how the Constitution can be thwarted to achieve ends that are inimical to its own founding ideals. In this regard, the court ought to have interpreted the silence within the Constitution in a manner that would have safeguarded its morality. Speaking on November 4, 1948, Dr. B. R. Ambedkar made his now famous plea for constitutional morality to be imbibed into the foundational document of the soon to be republic and ultimately be diffused among its citizens. The speech and its reference to the doctrine of constitutional morality have gained in judicial significance in the recent past.